Still with me, criminal defense attorney and former Los Angeles County prosecutor Josh Ritter. Now, Josh, you've been on both sides of the coin here. You probably know this as well as anybody. Those talks, the way they're being described are really how they go. I mean, you make these overtures and then you're kind of dancing around because you don't want to make any promises. So tell me about that a little bit.
Yeah, well, first of all, if you ask me to picture what a seasoned prosecutor from Georgia would both look and sound
He'd be the
like,
guy,
that is exactly the gentleman I would think of, yes. But he said a couple of things that I wrote down. He talked about how he told him he would help him down the road and that he could really help himself by being truthful. And this is kind of a common, it's not really a ploy, but it's kind of a common tactic to use that, like, listen, we're just trying to get the honest truth out of you. And if you're going to be honest and truthful with us, then maybe that can help you out down the road. But this is no promises given. This is not a grant of immunity. This is not saying we're going to give you a sweetheart deal. This is really just having a conversation. We're saying if you want to cooperate and you want to put your best foot forward and now say who's implicated and who's not and what your involvement was, and you're going to be truthful about that, then maybe that could perhaps help you out down the road. And it's all kind of vague and ambiguous, and it's certainly not a grant of immunity. Toward the end there, what he talked about is if you used him at a grand jury, that he would give him use immunity, which is pretty common when they can convene a grand jury to grant those who are going to testify use immunity, meaning immunity for what they say on the stand during that time. But it's not transactional or blanket immunity in the sense that they would never be prosecuted for that crime.
Yeah, so at the end of the day, that immunity is not something that the defense can bring up in court, correct?
It's not immunity in the sense that it's immunity to have him testify at trial. It would only be for the purposes of a grand jury indictment. So it wouldn't have the same impact as immunity that might be granted to someone if they were going to testify in court. And that's really what the defense is concerned with. They want to know, is there a bias here? Is there some sort of motivation behind why he might be testifying the way he is? And you can see how that would work out. If he starts pointing the finger at Mr. Ryan Duke, the attorneys for Mr. Duke are going to say, well, of course he's doing that because he's getting all these benefits out of it, and it's going to help him out with these grants of immunity or maybe leniency for him to give the kind of testimony he's giving, and therefore, jurors, you should not trust a thing he's saying.
Interesting. A couple of other issues came up as well by the defense, one of them being that he has these other open cases in another county, and they're pending cases, so he's not convicted of these crimes. They want to be able to use those to impeach him as well. Your thoughts on that?
Sure. So a common tool used in cross-examination of someone who has any kind of criminal background is you impeach them with their convictions, or you can impeach them with what's their crimes of moral turpitude, and that would be actual actions. If you're able to prove up that this person participated in certain crimes, you would be able to prove that or be able to impeach them with that. It's a little more difficult when you're not talking about convictions. When you're actually talking about proving the actions, it might involve calling other witnesses. But anytime you have somebody on the stand and you're trying to impeach them and you can show the head, listen, you're not someone who's trustworthy because of the actions you've taken part in before taking the stand here, convictions or otherwise, it's going to be helpful in your arguments to the jurors that this isn't a person you should be listening to.
The defense also made intimations that if the state decides not to call Bo Dukes, they would call him. Do you think that would be a good idea?
That's a really interesting point that the defense attorney brought up there. Maybe there's enough valuable information out of what Bo Dukes has testified to before that they think even if the prosecution doesn't call him, they still might feel that it's worth the fight to put him on the stand themselves. And what they're doing there in those pre-trial arguments is saying, well, listen, Your Honor, if we do, we're going to ask you to declare him hostile, meaning even though we're calling him as our witness, we don't expect to question him as we would under direct examination. We would expect to question him as we would under cross-examination, which would allow for leading questions and that more of that kind of aggressive interrogation that we're used to on cross-examination, because they might be dealing with a quote-unquote hostile witness to themselves at that point.
And so would they be still allowed to impeach him with whatever information the judge allows them to impeach them with?
I think they would, and I think that's the argument that they were making to the judge, is that it sounds like that there's case law in Georgia that would allow for that even if it's not your witness, if it's a witness that's quote-unquote hostile to you and you're cross-examining him, then it's all fair game at that point to use whatever kind of cross-examine tools that you would have. including prior convictions or prior acts of moral turpitude.